Why don't ever let children testify as to child custody issues is a patently stupid idea. I had lunch today with a former legal assistant of mine who is now a law student in Arizona. Over the summer, he shadowed judges in Maricopa County during their family court rotations. He told me that in Arizona, the courts permit children over the age of 10 years to testify in child custody proceedings. Are the Arizona courts administered by fools and sadists? Or could it be that the Utah District Court's near universal aversion to any and all forms of on-the-record child testimony from the child directly in child custody proceedings is a case of misplaced priorities? Could it be that the way Utah courts use appointments of guardians ad litem and or custody evaluators for the ostensible purpose of, quote, speaking for, close quote, competent witnesses who are minor children is a sophomoric euphemism for good old-fashioned hearsay, and that it ironically results in silencing the most percipient witnesses regarding issues in which they have the greatest stake? Could it be that the GAL reports and recommendations that are based upon purported interviews, but not verified interviews, with the minor children, when there is no objectively verifiable record of whether the interviews even took place, to say nothing of what was and was not asked and answered in the course of the alleged interview, are not fact or expert witness testimony? See State Ex Rel AD, paragraphs 6 and 7, 6 Pacific 3rd Reporter, page 1137, 2000, Utah Court of Appeals, 2016. And thus, inherently not evidence? Could it be that custody evaluator expert testimony and recommendations based upon their purported interviews with the minor child, when again there is no objectively verifiable record of whether the interviews even took place, to say nothing of what was and was not asked and answered in the course of the alleged custody evaluator interview or interviews, inherently can't qualify as expert testimony under Utah Rules of Evidence 702.